Good evening. Welcome to the October 20th, 2022 Kent County Board of Adjustment. At this time, we'll call to order.
Yes, sir. So we have Miss Hudson,
Present.
Miss Coleman,
Present.
Mr. Jenkins,
Here.
Mr. Nichols,
Here.
Mr. Cusick.
Here.
That's 5 present. You have a quorum.
Thank you. Introduction of staff, please.
Yes, sir. Good evening, everyone. My name is Jamie Fensky. I'm one of the planners here. I also have with me Scott Blair, who's one of our planners. We have Mark Kennedy, our IT staff, and Mr. Fred Townsend, our legal counsel.
Thank you. And at this time, we'll stand up for the Pledge of Allegiance. Any additions or alterations to the agenda?
No, sir.
Thank you. And public hearing introduction.
All right, so good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. Please note that the variance application A-22-33 for Kevin and April Lafferty has been postponed to the November 17th, 2022 Board of Adjustment meeting. And the appeal application A-22-28 for Morgan Branch Solar LLC, owner Christopher Cartanza, trustee, has been postponed to the December 15th, 2022 Board of Adjustment meeting. This hearing is being conducted for the purposes of providing the citizens of the county an opportunity to present testimony on the applications before the Kent County Board of Adjustment. Everyone will have the opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there should be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. For the procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record, and a common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471, or check the Kent County Planning Department website to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published in the newspaper on October 2nd, 2022. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. This time, we're going to have a statement by counsel, the purpose of which is to help those who are going to give testimony this evening an opportunity to understand what is appropriate as testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denny. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. Area variances are the types of variances that this board hears most often. One of our applications tonight, though, will not involve an area variance request, so when we come to that, we'll pay particular attention to the applicable standards of review. But generally, we're here to consider requests for a relaxation of area restrictions. The legal standard for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restriction would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And also, this consideration is where the board considers whether the applicant is seeking more relief than is minimally necessary to relieve the difficulty asserted. In general, the board is not to consider factors other than the 4 I've listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on 1, the nature of the zoning district, 2, the characteristics of the area, 3, whether the requested variances would seriously affect neighboring properties, and 4, whether applicants are confronted with challenges that rise to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is not authorized to resolve those disputes. Thank you.
Thank you, Mr. Townsend. And just as a matter of housekeeping, I arrived late, so just so we know in the roll call that Joan Denny is present.
Yes, ma'am. Thank you.
Okay, so whenever you're ready.
First, we have application A-22-27 for Mountain Consulting for Rouse Insurance and Financial, LLC. The applicant is Mountain Consulting. The owner is Rouse Insurance Financial. The present zoning is AR. Proposed variance is a variance from the 75-foot front setback from the right-of-way on a major roadway to build a house. The present use is vacant. Proposed is a residential home. It's in the Levy Court District 6 for Mr. Howe, located on the south side of Halltown Road, about 0.23 miles east of Crystal Road, southeast of Hartley. Here you will see that they are seeking a variance from the 75-foot front setback to be proposed at 50-foot front setback. There is a 15-foot side setback on this parcel. There's also a blue line stream there in the rear that they have to stay 100 feet from the top of bank, but they have applied for a waiver for that to be 50 feet from the top of bank. You will see also on this drawing the original dwelling that has already been removed. Here's looking at the property from the front of the road, down Halltown. And in the other direction, you can see the stream there. Again, across from the road at the stream. This is from the side property line where it was showing the 15-foot side and the aerial. If someone would like to come up for the application, please state your name and address and allow our attorney to swear you in.
Good evening. I'm Troy Adams with Mountain Consulting.
Mr. Adams, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do affirm.
You may continue.
Good evening, everybody. Glad to see you tonight. It's been a while since I've been at the podium, but it's good to be here, and thank you for hearing us. So basically, as Ms. Fensky stated, Mr. J. Rouse purchased his property in May 2021 via sheriff's sale with the intent to redevelop it because it's been vacant for at least about 10 years, okay? And as she stated, there was a mobile home previously there. So he purchased it with the intent to put a newer home there that fits into the character of the neighborhood, which is, maximum dimensions that we're showing is about 30 by 50, okay? So as he got into better understanding what he has here, obviously we have a few restrictions. Halltown Road being a major road requires a 75-foot setback by code. Also, the main prong of the Tappahannock ditch is on the southerly side, along the southerly boundary line of the property, the rear line. So a 100-foot setback is typically required from a blue line stream. So it's a couple things there. The blue line stream setback of 100. Then there's also the maintenance easement that's associated with the tax ditch that we have as a restriction back there. The side is okay. No issues there. Basically, the left side of the property, as it is on the screen, is where the driveway, existing driveway is. So we want to reuse that. So that's what this all comes down to, is that 75-foot setback is restricting us from getting a properly sized, livable home on this property. And one addition, he did do the proper soil evaluations and whatnot, because we had to do private septic here, on-site septic. So in that front portion, that the green band there that shows 50-foot proposed front setback is where there's an acceptable area for sewage. So unfortunately, Mr. Rouse was planning to be here tonight. Had a trip to Baltimore to do, and traffic is not being his friend. So he apologizes for that. So we're just here to represent him as well as we can, and he will return the sign. Any questions for me?
Okay, so first of all, traffic is not my friend today either.
I bet.
Does anybody have any questions or comments? I have none either. And just as a matter of record keeping, the staff recommendation for this is approval. So
Awesome.
I guess that's it.
Okay, well, thank you, everybody.
We put something on the record real quick.
Sure.
So would you describe that as a oddly configured lot?
Oh, definitely. This is irregularly shaped, for sure. So by applying the typical setbacks that are required by regulation, it would merely almost make this close to a very unbuildable lot.
So if the rear lot line there that I think is shown is 62.25 feet, if that extended all the way across the road frontage, you'd have something closer to a square lot, is that right?
Yes.
But you still have that stream to contend with,
Yes, we do.
right?
Yes, sir.
So even if you had a square lot, that stream is creating a difficulty for you.
Yes, we actually probably would still have the same outcome as we have right now.
So the distance, what's the distance between the 66 feet to the back corner of the proposed house and to the 75-foot setback?
Oh, that little distance right there?
Is that your building envelope?
Yes, the purple rectangular line is the house itself. So what's not shown on there is the rear setback is basically just a second.
Is it like 10 feet or less?
The rear would be 25, but because of the Blue Line stream, it has 100 feet from the top of bank.
What I mean is the window that you have between the front yard or the setback from the road and the setback from the stream is extremely narrow.
Yes, I don't know what the scale of it is, but it's not much footage there.
So could you talk about the house that's proposed? Is it a modest-sized house? Is it a large-sized house? I don't see dimensions.
Sure, it's about 30 by 50 building dimensions that we have in mind to place within the buildable area.
And how would you characterize a 30 by 50 house in terms of it being typical or being large or small?
Well, that's about 1,500 square foot, which is, about the average today, most likely that's being built that's affordable right now.
It's a smaller home, though.
Well, yes. More than likely envision this being a rancher, modular style residence.
That's all I have.
Thank you, Mr. Townsend. Does anybody else have anything?
Yeah, I have a question. The property owner is Rouse Insurance Financial LLC, correct?
Yes, sir.
But the intention here is to build a single-family residential dwelling, not a business entity.
Exactly, just for residential only.
Okay, thank you.
Yes, sir.
Anybody else? Thank you.
All right. Thank you all. Have a good evening.
Is there anyone else that would like to speak in favor of this application?
If there's anyone joining us online that would like to speak in favor of this application, please press *3 to raise your electronic hand. None in favor online.
Thank you. Is there anyone that would like to speak in opposition of this case? Please state your name and address and allow our attorney to swear you in.
My name is Phyllis Meyer. I own the property that runs the driveway, goes to the back of the property. My home address is 236 Laurel Lane, Smyrna, 19977.
Would you just pull the mic down a little closer? Thank you.
Better? Okay.
So, Ms. Meyer,
Yes, sir.
it was Meyer, right?
Yes.
Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can continue.
Okay. I have two concerns. One is that it's going to impede the vision of my occupants living in the property on the back, coming out of the driveway for the westbound traffic on Route 8, depending on where that house is actually located. My other concern is the septic system. Where the drain field is going to be, is it going to be too close to the ditch and it's going to contaminate the ditch water? If it does that, it will also contaminate the property waters on all of the properties along that ditch line. And those are my concerns.
So, it's difficult for me to look at this map and be able to say one way or the other about impeding vision. However, as far as the septic and drainage, DENREC will be involved in that, and they, at this stage of our lives, they tend to make sure that that doesn't happen. So, I mean, that's all permitted by DENREC's involved, and so I don't think that's a concern. As I look at this and I think about your neighbor, where the house is, and I'm looking at this thinking your neighbor is, as we look at that on the left side, yeah. The left
The
side.
driveway to my property is right here.
Okay,
I own this property in the back.
okay. And so this,
I have tenants that live back there.
and where do they ingress egress, right? Where that blue line is?
I'm sorry, say that again?
So where the blue line is on the map, it appears as though there's a lane or a driveway. And is that
Yes,
the
ma'am.
ingress egress?
Yes.
Okay. And so it would appear to me that this is 15 feet back? No, that's a sideline. It's like roughly, it's 50 feet back. And so I would think that 50 feet would be adequate visibility for your neighbors from that driveway.
Okay. I'm just thinking of the way the road angles right there.
Was there there was an existing house there that's been removed?
Yes.
Excuse me, it was a small trailer, more like a camper size, that used to be there.
Thank you.
The location of the trailer was, do you know roughly how many feet back it was from?
It's on the map
It
there.
was in the middle
the
of the
map.
wooded areas. I'm not sure exactly how far back it was.
So it's about 45 feet to that corner there. So that 50-foot line
I would
is
say it was
the,
probably like right in this area, closer back than where this dwelling is showing. It was further back. It was like a camper size trailer. It wasn't a full-size trailer.
But this structure is going to be located almost entirely behind the location of the former dwelling.
Not from what I'm seeing on there, but
Well, that's what's depicted on the application, right?
That's correct. So ma'am, if you'll see, this is Halltown Road there where the red is. So that's the front. This orange here was the home that was there that has since been removed. The proposed home is going behind that.
okay.
Anybody else?
So you were under the impression that this
It was
home
going
was,
to be further forward.
okay, does that comfort you to see that it's
Is
going?
it a single
Well, the
floor or double, two-story? Is it a single story or two-story?
per his testimony earlier, it was a rancher.
30 by 50.
Okay.
But I don't know that our approval would speak to whether they would build a one or two story home.
Nope, it won't.
No, that's part of the permitting process. That's
But I'm not sure how the height of the structure is going to make any difference if you're trying to spot vehicles.
you're trying to look on one side or the other of it, essentially. And again, as we see in our drawing, it's behind what's there, what's existing there. So,
Well, like I said, my biggest concern is contaminating the ditch.
and DENREC will take very good care of that.
There's a septic permit that they have to file that DENREC will review and make sure that they're in regulations.
I understand
They
a
have
lot
to
about septic systems.
Yeah, they are in charge of compliance, and we would have no say one way or the other over what DENREC decides. They're pretty much the governing aspect of this type of a project.
That was all, that was my concerns.
Okay, thank you.
Okay, thank you.
Is there anyone else that would like to speak in opposition of this application?
If there's anyone joining us online that would like to speak in opposition, please press star 3 to raise your electronic hand. No hands raised online at this time.
Thank you. Seeing no one, the public hearing for A-22-27 is now closed. Next, we have application A-22-29 for the state of Delaware. Is there someone present to speak on behalf of that application? Thank you. If you just want to stay seated for just a moment, let us open the case. Thank you. All right, so the present zoning is AR. The variance is a variance from the requirement that all entrances and exits from the site be set back at least 10 feet from adjoining property lines to allow the submission of a site plan. The present use is residential and agriculture. Proposed is same. It's in the Levy Court District 5th for Mr. Sweeney, located on the south side of the intersection of Kersey Road and Friedel Road, west of Viola. Here you will see the entrance that is existing, that is crossing the property line. The property line there is in blue. The entrance is in red. They are seeking to submit a site plan to exchange out the existing office that's there for the State of Delaware Wildlife Area and put in a slightly larger office area. Here you will see the existing site. Looking at the office building that's there, they will be changing out this one. Looking down the road. And in the other location, or sorry, other direction. Here's looking at the entranceway. And the site does cross both sides of the road. We will be on the south side of the road. And farther out. So gentlemen, if one of you would like to come up, state your name and address, and allow our attorney to swear you in.
Good evening. My name is John Selesky. I'm with Century Engineering, and I'm here on behalf of the Division of Fish and Wildlife to support the.
Sir, would you pull the microphone a little closer to you? Right, thank you. Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please continue.
Yes. So good evening. The nature of the request, as stated, is the improvement of their existing office facility and some of the site. So the site is completely owned by the Division of Fish and Wildlife. They're going to use the existing entrance is going to stay just like it is. So the general nature of what is being requested is a byproduct of wanting to improve, and basically they grew the footprint of the existing office facility. So in line with the zoning, there's consistent zoning there. Use is not changing. The entire site is going to be it's an improvement. So really no change in use, and so the request for the variance is because there's really no change in the access that's required for the facility, and they own both sides of that access. So in addition to the request for the setback is also creating a cross access as well. So are there any questions?
Does anybody have any questions? So essentially what they're doing is they're removing this office building and replacing it with just a slightly larger footprint, and that would require the 10-foot variance.
That is correct.
Okay. Anybody else? Thank you.
Oh, you're welcome.
Sir, if you would just state your name and address and allow our attorney to swear you in.
My name is Dylan Nicholson. Applicant, I guess would be best way to put it, 782 Kersey Road. Same application or same address for the site being proposed for the variance.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. So I don't know if John, I think he had mentioned it, but the wooded property right off to the west, on the west side of this site, the entrance now, we currently own. The state won't sell the property. It will stay with us forever. It's currently, it's all wetlands, so nothing's unbuildable. There's really nothing that can be done with that property other than maintained as Habitat for Wildlife. About all I have for that. Any questions?
I'm sorry, I missed your name. Could you say that again?
Dylan Nicholson.
Thank you.
Mm-hmm.
Okay, so anybody else, anybody have any questions of Mr. Nicholson?
Nicholson, yep.
Looks like no. Thank
Awesome.
you.
Thank you.
Is there anyone else that would like to speak in favor of this application?
If there's anyone on the call that would like to speak in favor, please press star 3 at this time to raise your electronic hand. See no hands raised at this time.
Thank you. Is there anyone that would like to speak in opposition of this application?
Again, if there's anyone online that would like to speak in opposition, please press star 3. No hands raised online.
Thank you. At this time, we will close the public hearing for application A-22-29.
Okay, the next application for the evening is A2230. This is Jonathan and Christina Fitzwater. Is there anyone here tonight to represent this? Just raise your hand for now and we'll call you up. Thank you. Okay, so again, this is A2230. Jonathan and Christina Fitzwater, they are seeking a variance from the requirement that an accessory structure used for a home-based contractor establishment be set back from the public street right-of-way, the rear distance of a minimum of 30 feet beyond the rear elevation of the main dwelling, and at least 15 feet from all side or rear lot lines to enable a home-based contractor establishment. The property is located on the southeast side of Nault Road, 50 feet north of Massey Drive, west of Dover, Levy Court District 6, and it is zoned AC. So Exhibit B shows you, and these are existing buildings. First, and you'll see these in later photographs. First, there's an accessory structure that's used for a garage currently, and next to that is a shed office. Again, both of those are required because they're being used for a home-based contractor to be 30 feet behind that rear elevation, and actually both are in front. And the shed office does meet the 15-foot side setback, but you can see the accessory structure, that is the garage, is only 11 feet from the property line. So they'd need a 4-foot variance to make that legal. So this is kind of an aerial view of it. The office shed probably was or must have been added after, but you can see the main structure there, the garage, as Jamie's pointing out. This is a photograph of the posting with the sign out front, just to give you the character of the area. This is the dwelling. Home-based contractors are required to be an accessory to, again, home-based, so the owner has to, or the business has to occupy the actual dwelling on the premises. This is looking one direction down Nault Road, to give you a character of the area. This is showing the property line there. As you can see, there's either Leland cypress or arborvitae on the property line to give you some sense of where that property line is in relation to the accessory structure being used for a garage. And in this photograph, you can see the office there, the shed with the air conditioning unit. That is the second accessory structure being used for the office as part of this home-based contractor establishment. And this just gives you an idea that they are not forward of the house. That would require they be 100 feet from the property line, but that is not the case here. Again, it just kind of gives you an idea of the placement of these two structures. And this is the rear of the property. And this is an aerial photograph giving you some idea of the surrounding area with the building there. And this is a higher up aerial photograph. And I would note that this is the first step. So the purpose of this hearing and the variance is to legalize the buildings. That does not legalize the business. The next step, should the variances be granted, is they will have to go through the home-based contractor process, which requires additional neighbor notification. So this tonight is just a variance to grant, to legalize the placement of the existing buildings. Okay, with that, if we can have the applicant please come up and give your name and address, please, and allow our attorney to swear you in.
Good evening. I'm John Fitzwater, address 1806 Nault Road, Dover.
Mr. Fitzwater, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. We're looking for a variance. We got the building put up in plans to do a business. When we got the building put up, we didn't know we had to have it offset of 15 feet and 30 feet behind the house. If we would have done it then. So now that it's already put up, we're hoping to get the variances. In the one picture, we made sure that they knew there was at least 12-foot thick pine trees between us and the house next to us, even though we're only 4 feet shy of that variance. And that's really not much it.
Anybody have any questions? So I have at least one to start with. When, at the time that you applied for the permit to establish these structures, and I realize at the time one was a shed, but at most the pole building, when you applied for the permit for that, did you make the county aware that your intention was for a home-based business?
The pole building company got the permits, and they knew I was putting a business in there because I had to have the concrete set for a lift, and they knew what I did for a living.
So the permit process was all done
Through Delmarva Pole Building.
by Delmarva Pole Building. Would that be true of the shed as well, or the shed was just a separate?
The shed was a separate thing.
Okay.
Yep.
Okay, and when they applied, they did know that what your intentions were?
Yeah, they
for-
did. And all
Okay.
it said on the permit was it had to be 5 feet off the property line, behind the front of the house, which it is, and then it couldn't be bigger than the footprint of the house.
Okay. Anybody else with questions?
Just, if I could ask staff, once again, that accessory structure, the garage, was legal at that location, were it not being used for?
That is correct, Mr. Townsend. It's just a 5-foot setback, and as the applicant said, can't be larger than the house, and it cannot be forward of the house, or as the board probably knows, then you have to be 100 feet from the front property line. So all the conditions were met if this were not being used for home-based contractor.
And the shed office is also located in an appropriate location without,
Correct, and sheds, actually accessory structures now under 300 square feet do not need a permit anymore in the county, but they do need to meet setback and other standards, which in this case it does.
so that, a variance is needed for that shed office or not?
It does, Mr. Townsend, because it's actually being used as the office as part of this building, and I confirm that with the applicant.
Mm-hmm. Okay, question for the applicant real quick. Those trees, are they on your property?
No, they're, I'd say 3 feet on to the other property, but they almost touch my pole building. That's how far they come out.
Okay, so those are your neighbor's trees, not yours?
Yep. But I'd say at least a third of the trees are hanging onto my property.
But in the event that your neighbors decided they no longer wanted to care for their whatever reason, that's their trees and their prerogative?
Yes.
Okay.
Yep.
And then if the shed, because it didn't have to be permitted, if it was just used as a shed, that looks good. But because you're making this office, if you were at some point like to meet us halfway, is it possible for you not to utilize the shed as an office?
If we had to, yes.
Not
Right
the
now,
most
it's-
convenient thing, but
It's not convenient. So it's the office / somewhere for the customers to stay out of the shop for safety hazards.
sure. Okay. Anybody else?
Yeah, I have one. Could you just describe the financial impact, either with you not utilizing this business, and then the financial impact on you having to move this building?
I have everything tied into this shop. I don't have anything left. It's just me and my wife that work there.
And say the rough cost of that, like the relocating, it's pretty pricey.
Yeah, the buildings alone is 25 to 30 grand. Well, that was 2 years ago. These days, it's probably a lot more.
Thank you.
Could you tell us the nature of your business? Are you working on cars?
Oh, yeah, auto repair. Yep.
Thank you. For your business, would you have unusable cars hanging around all the time, or is it just as you're working on them?
Most are in and out in one day. There are times I have to wait for parts. They might stay a couple days, but they're usually just a cycle.
Thank you.
Anyone else?
Did you have a shop like elsewhere before this, or?
I worked at Firestone for 16 years.
Okay.
Yep.
I have a question. Are there any particular hours that you're regulated by in terms of your operation, or your hours of operation?
It's usually 8 to 5 Monday through Friday, and every once in a while on a Saturday.
When you gave that price previously about the construction cost, did that include the concrete as well?
Yeah, when I got the building put up, it was 25 grand, including the concrete.
Anyone else?
So how long have you been conducting business there?
Just over a year.
And you're still in operation right now?
Yes. Yep.
And he's permitted to operate because he's got a pending application. Is that right?
He does not, Mr. Townsend. This came to the county's attention through a complaint, and it's currently being investigated. And one of the remedies is he has to be approved as a home-based contractor, but first the buildings have to be legalized with the board before he can proceed with that.
Right. So do you want to speak to you may be aware there was a complaint.
Yes.
The complaint may have involved noise. I mean, can you speak to how much noise you generate at that site?
So one of the complaints was my compressor. I felt if they would have said something, I could move the compressor to the other side of the shop, so then they wouldn't hear it. They talked about horns being honked. That's literally just people driving by who say hi. They do that when I cut grass too. They talk about squealing tires. I've never done that in my own driveway. People do it coming out of the neighborhood. There's a lot of traffic that come in and out of the neighborhood behind me. They talked about, I want to say that was the noise complaints. The compressor, cars. They said there's so many cars going in and out. Like I said, the neighborhood has so many people that go in and out. In Nault Road, and I didn't know this until I moved in that house, it's a very, very busy road.
If you were denied the variance and you couldn't have your business there, would you be able to operate someplace else, or is this you would have to close up shop and go back to Firestone type of thing?
I would hope I could find a shop somewhere I can keep my business going.
But how much would you say would that cost you to go find something? More than the building, or?
It really depends on what I could find versus rent, and I can't finance anything right now because I'm such a new business.
Anybody else? Thank you.
Thank you.
Thank you, Mr. Fitzwater. Is there anyone else in the room that'd like to speak in favor of the application? Yes, sir. Please come up, state your name and address, and allow our attorney to swear you in.
Excuse me. Kelvin Johnson, 61 Massey Drive, Dover.
Mr. Johnson, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do. I just wanted to read a brief letter I wrote. I procrastinated and didn't get it in the mail in time, so it's very short. I'm providing this correspondence in support of the variance request mentioned in the included notice of application. I share a property line. That's my house, the White House just on, that's it, yes. In question, although it's not really a property line because we have that small piece of, I guess, land there in the middle. I believe the building is constructed in a manner that does not create an eyesore or present any safety concerns that I can see. Although being used as a home business, the property is always well maintained. I patronize the business and believe it to be good for the surrounding community. It provides a great service and at a great price.
Does anybody have any questions?
In your opinion, Are there any loud noises or squealing tires, horns coming from the property?
No, you'll probably hear more horns coming out of my development, or cars coming out of my development. There's more traffic there. So far as noise, the only noise I hear is the house on the opposite side of those trees when the band is practicing.
Thank you.
But the air compressor, do you hear the air compressor?
No, I don't hear any noise. It's very quiet. I have no complaints. We're outside. If you zoom in on that photo, you can see my deck. We're outside all the time. My wife and I.
Will that mic back up to your?
Oh, I was saying if you could, see if you can see my house there. You see, that's my deck that the red arrow's on. So we're outside, my wife and I, most of the time. So we don't hear any noise. It's not a problem.
So are you at home during the week typically?
Yeah, I'm retired, so I'm home all the time.
There you go. Okay.
So essentially, he states his hours of operation are pretty much very reasonable hours, 8 to 5, Monday through Friday, occasionally a Saturday, probably for catch-up is what I'm assuming he meant in his testimony, but at any rate, they're very reasonable hours.
Yes, and as I understand it, their Saturdays are by appointment only, so if you don't have an appointment, it's not like you're just going to show up.
Okay. Anybody else? Thank you.
All right, thank you all.
Thank you. Would anyone else in the room like to speak in favor of the application? Yes, sir. Please name and address and allow our attorney to swear you in.
Arthur Valdesir, 1777 Nault Road, Dover.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. I live across the street, catty corner of him, and I've been there, I guess, about 12 years. And when he opened it up, I mean, there's no major noise or anything. There's like 48 houses in the development, and the cars coming out of there make all the noise and stuff. I have friends go by that beep the horns and stuff going by my house. I sit back off the road farther, and they still beep the horns and everything. And Mr. Walham, the neighbor that the issue is with, he trains his dog with a 22 shot thing that shoots off a.
Yeah, sir, I would ask you not to, I mean, you can talk about the character of the area and whether it's generally noisy or not, but this board is not going to consider any criticism you might have of the neighbor's activities.
Okay, well taken. But there's other noises in the neighborhood that go on that happen, and loud music and everything else. I hear more noise from the neighbors across the street in the development when they have a pool party than I do from what comes out of John's shop. It's crazy, but it is what it is. But yeah, there's never been an issue with anything as far as noise coming from there. I've got a louder air compressor than he does in my house across the street. So I don't know, I've never had a problem with it, and it is what it is, but that's basically, I'm in favor of it if everything goes according to plan.
Anybody have any questions? Thank you.
You're welcome.
Thank you. Is there anyone else in the room who would like to give testimony in favor of this application? In favor?
Hello, good evening. My name is Nicole Smith. I live at 1733 Nault Road in Dover, so right next to the Valdesirs and across from John and Christina.
So, ma'am, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. So I also was a procrastinator on getting my letter in, so I'm going to read it. This letter is from both my husband and I. We're writing this letter in support of the request from the business and the property owners regarding the placement and location of the building utilized for auto care. As a neighbor residing at 1733 Nault Road, we were served with a letter mentioning the reason for the hearing and requested input from myself and other nearby residents should we wish to contribute an opinion. In reading the initial complaint that was filed, We immediately took issue with the specific word constant, which was frequently used in the letter of complaint. This word means continually over a period of time, constant use of a loud air compressor, constant banging, constant engines idling, so on and so forth. Being a nearby resident, I'm aware of the activities that take place at this business throughout the day and occasional weekend. I would assure the board that there's nothing constant of any of the above mentioned activities. I feel in an effort to bolster the argument of the complainant, those words were added as a way of creating the vision that a one-person auto care shop with 2 bays for work would sound more like a pit stall at a NASCAR race than the very uneventful changing or rotating of car tires that would likely need the use of an air compressor for a matter of minutes in total. Vehicles are usually dropped off each evening and picked up in the afternoons the following day, 8 to 10 on a good day. Regarding vehicles idling, I struggle to envision someone working in an environment that, given his many years in the auto repair business, would knowingly subject themselves to the health hazards associated with such an activity. The mention of health concerns due to emissions seems egregious as well, and that the dissipation of any emissions from 8 to 10 cars a day moving in and out of the shop would in all likelihood be a non-factor given the distance to the nearest residence and actual limited amount of idling that takes place. I have been working from home part-time over the past 3 years since the pandemic, but over the past year plus that auto care has been open, many days with my windows open, and I do not hear the screeching tires, horn blowing, constant banging, etc. As my neighbors have mentioned, most of the tire squealing comes from the neighborhood, not out of John's driveway. I would venture to say that if anybody squealed tires out of his driveway, he would ask them to not come back. But I would counter one of the complaints was about the beeping of trucks, and I would counter to say that after Thanksgiving during the busy holiday season, the same beeping can be heard by the many Amazon trucks making deliveries to all of the houses in the neighborhood. On a personal note, our children frequently play over at the Fitzwaters residence during the days when they don't have school. They are friends with the Fitzwaters daughter, and we would not have our children over there exposed to excess noise and emissions. Furthermore, neither of our children have ever complained about any noise or fumes while over there. In fact, this auto care shop is the cleanest auto repair facility I've seen in many years. I've worked in the environmental field for approximately 15 years, and it is one of the cleanest places I've ever seen. Mr. Fitzwater takes great pride in keeping his facility clean and organized. My final point and argument in favor of granting the variance is that this process was undertaken by the Fitzwaters to build a structure that would house a home-based business. A year after the business opened, which provides the sole means of income for this family, a complaint was filed. Now this business and the livelihood of a family hangs in the balance. I also think it should be noted that the Fitzwaters are requesting a variance for the physical location of the building where the auto repair activities are taking place. Following the county's ordinance of where the building should have been built for this purpose would not alleviate the above-mentioned complaints if they were in fact true. In closing, the Fitzwaters have our family's support to continue doing business as they have since it has opened. I also would say that they are wonderful neighbors. They are great in the community, and having a business located in this area is actually really great for the safety of our neighborhood. People slow down more down the road. As one of the neighbors said, it is a very, very busy road, and having the business there actually seems to have slowed down traffic a little bit, which myself as a parent of 2 young kids, I greatly appreciate. So thank you for your time.
Anybody have any questions?
Could you tell us once again, I think before I swore you in, you started to tell us that you lived in the vicinity, and maybe it's apparent to everyone but me. Where are you?
So Mr. Valdesir, he is just catty corner. If you go across the street to the left, our house is the next one. So we are right there. So we are catty corner to the business.
And do you understand that this body here is authorized to grant relief from the zoning code with respect to the location of those 2 buildings, but but we're not here to authorize a home-based contractor's establishment?
Correct.
And if you wanted to add comments such as the ones you've added, you would need to to influence the decision, you would need to appear or write a letter at a later date.
Absolutely, would have no problem doing that.
Anybody else? Thank you.
Thank you.
Thank you, Ms. Smith. Is there anyone else in the room who would like to speak in favor of the application? Mark, is there anyone online who'd like to speak?
If there's anyone joining us online that would like to speak in favor, please press *3 on your phone right now to raise your electronic hand. See no hands raised online.
Thank you, Mark. Okay, is there anyone in the room who would like to speak in opposition to this application? Opposition. Anyone in the room? Anyone online who would like to speak in opposition?
Again, if there's anyone joining us online that would like to speak in opposition, please press *3. No hands raised online.
Okay, thank you. Hearing no more testimony in favor and opposition to A2230, the hearing is now closed. Okay, the next application is A2231, Garrison Lake Farms Limited Partnership. Is there someone here tonight to represent it? If you could just wait and we'll call you up. Okay, thank you. Okay, this is a little unusual. This, again, A2231, Garrison Lake Farms LP, seeks a variance from the requirement that any development proposal containing at least 50 lots or at least 5 acres, whichever is lesser, in FEMA delineated special flood zone area where base flood elevation data are not available shall be supported by hydrologic and hydraulic engineering analysis to determine the base flood elevations and floodway delineations to submit an application for a residential subdivision. This property is located on the south side of Brentford Road, about 163 feet west of Ryan Road, southwest of Smyrna. This is the Levy Court District first, and it is zoned AC. And just a little background with the board, these are pretty rare. We've only seen one before. It was Forest View Avenue Animal Hospital and Route 8. That was back in 2020. So this actually comes out of Chapter 188 of the County Code, not typical 205, which most of these bulk and area variances that you see come from. And this is different, and you will see in the staff report, hopefully you've looked at it, this really, the 4 quick check criteria aren't used as a kind of a basis for granting this type of variance. It's based on the 11 criteria, and you will see the applicant's response to those as well as staff. And then in granting the variance, you need to take into consideration the 7 factors listed after that. So just keep that in mind. Again, this is different than the run-of-the-mill quick check 4 criteria. So please keep that in mind as you kind of hear testimony on this one. So again, this is just kind of the area in question. Hopefully you've read through the report again. Again, it's not a Balkan area, the standard setback thing. The applicant will speak to, their justification why you should allow them not to have to do this study. And just to give some idea, this again is, there's a proposed residential subdivision going on this property. Right now it's wooded, and you can see the for sale sign. This is the front, kind of give the character of the area. Up and down, there's an existing residential subdivision on either side. Anyone who knows Brentford Road south of Smyrna knows there's a lot of residential subdivisions along this road. And if you go in the aerial, yeah, and you can see this particular proposed area. There's no lot shown on there now, but you can see the outline, and you can clearly see all the residential subdivisions around that. Is this the end of it? This is just a higher up again. You can see the residential subdivisions. And with that, if the applicant, Mr. Lobdell, is that, yeah. And we do have your PowerPoint. We've uploaded it. The formatting's a little different, but all the content and the words that are there, hopefully that suits you. Or attorney to swear you in, please.
So before I do that, when it comes to voting on a motion for this, you're going to be asked, as you always are, to give your justifications. Well, your justifications in this case need to be quite a bit more extensive than just addressing those 4 considerations that we have in Quick Check, 2 of which are typically the dispositive considerations. So if you're going to approve or deny the application, you're going to need to make reference to all of these considerations. So it's going to be a little bit of a struggle, I'm sure, when that time comes, no matter how well or how much merit the application has. Are we ready? So, Councilman Lobdell, can we have your address, please?
630 Churchman's Road in Newark, Delaware.
And, sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Both did. So, thanks for the introduction on the project. I just want to give a quick background on this. This subdivision was initially recorded in 2011. When they're recorded, they're good for 5 years, where they sunset if construction hasn't started, unless you get an extension. So we had one extension on the project that in 2016, and it was not renewed in 2021. So last year the project was sunset and expunged from the records. So we are now coming back through the subdivision process with the same exact plan that we had before that was approved. And as part of that subdivision process and the submittal process, we were told that some of the code had changed a bit, and the code regarding the floodplain issue was since added between 2011 and today. So before we can start the subdivision process, we have to get a variance for the floodplain study on the property. Oh, wrong button, sorry about that. Okay, so on this is similar to the diagram that was up earlier. If you look down here, you can see the blue area on the site represents the floodplain that is currently depicted on the FEMA maps. Downstream from the subdivision, in this area here, where the red stripes are, this is Garrison Lake Green on the other side. There is floodplain mapping that has elevations up to the railroad, and that elevation is mapped at elevation 11. When we first got this project approved, we used that same elevation on our property and just carried it up through the site, and that's how we mapped the 100-year floodplain. The new regulation states if it's not mapped as an elevation on the floodplain, we have to do a flood study. So in looking at this is the subdivision plan, that layout that we have. If you look back in this area here, this is where the elevation 11 is on the other subdivision. And the red line coming through the site here represents elevation 11 on our property. This is a little closer up view of it in the back end of the site. This is also, there we go. This is the red line here is the floodplain line. Our property, the closest point of any lot to that floodplain line is 66 feet. But the key to that topic there is the elevation of that property is elevation 24, which is 13 feet above the floodplain elevation that we have mapped on the site. So this is the code requirement as far as what's required on the site. The first red area up here, this first red area up in here depicts that the floodplain study has to be completed. But there also is language in the code that in subdivisions in which proposed lots are located outside of the floodplain, completion of the study may be waived provided the subject area is designated and restricted as open space or conservation areas. So I'll go back to this property here, slide here. You can see everything within the floodplain area that we have mapped as 11 is going to stay in open space and be preserved that way. There's no development proposed in there. There's no crossings. There's no structures, no playgrounds, nothing. And it's going to stay that way. This whole area here is all marsh and wetlands, and we can't, it's going to remain environmentally protected. So we're seeking a waiver for the requirement to do the flood study in order to allow the project to proceed through the subdivision process without delay. So I'm here to answer any questions you guys may have.
Yes, I have one. So what is your primary reason for choosing to not do the study? I'm assuming that one could be cost, but fill me in, please.
So two big reasons, well, three, I guess two are tied together. One would be the cost and the time. To do a flood study of this magnitude, I guess, would run between $40,000 and $50,000. And in addition to that, we would have to deal with FEMA to have the floodplain maps updated, and that process usually takes at least 2 years, if not longer. So that would cause significant delays in the project that we're trying to get reapproved. And the other issue is just there's other subdivisions on the opposite side of this area that actually have lower grades than we do. They're like elevation 17. They don't have any issues with the flooding. Just from my experience and my background, I don't believe that if we did a study out here, it would raise the floodplain by 13 feet and bring it up to where it would affect the properties that we're proposing. So if it changes at all, it will be minimal, and it still wouldn't affect anything we're proposing.
So if I understand the way this is laid out, what your plans are, you would be nowhere near the floodplain, correct?
No, the closest property corner is 66 feet, I think it is. 65 feet is the closest property corner to what we have mapped as a floodplain. But it's 66 feet, and then there's also a 13-foot drop within that 66 feet. So we wouldn't come close to that area.
What is the anticipated time frame that you would plan on starting construction on this?
We're already in the process of re-getting our letter of no objections. So we're ahead of the game on that issue because the project was relatively unchanged except for some notes and details. Assuming we can get this waiver, we would request to be put on the next planning agenda to start that process, which takes a few months. And over that time, we would wrap up construction. So I would think the owner would like to get started potentially by spring or summer of next year.
Have the owners already bought this property, or is this like a conditional, if they don't get the variance, they will not purchase it?
Yes, correct. It's conditional. It's more of a timing issue than anything, especially with the housing market fluctuating.
Anybody else have any questions? Go ahead.
So, Mr. Lobdell, you mentioned your background. Could you tell us a little bit about your background?
I'm a civil engineer. I've been practicing in Delaware for almost 25 years now. So we've dealt with a multitude of projects like this and commercial projects like this. We're working around floodplains and wetlands. We've done quite a few flood studies, and you can kind of tell by looking at the area that's draining to it and the basin area itself that it's not really going to have an impact just based on previous stuff we've accomplished.
And can you inform the board with a little more specifics as to what an H&H study might reveal, or what's the purpose of it? And
yeah, the study just basically takes the drainage area to this. The analysis point would be at the railroad, because that's where the pipes are. So the study itself would take the entire area that drains to that, and we would analyze it and run a 100-year flood study basically to determine where the elevation would be for a 100-year flood with that pipe constraining things. This is such a large drainage basin. It would be pretty extensive, the study that would have to be done. And in order to do that, we would need to go out and pick up topo for everything in the surrounding area, use some of the LiDAR maps, and there would be a lot of work that would have to be done. And the topo we would have to pick up would be in wooded areas and the marsh areas, and it would be pretty extensive.
Are you bringing up the grade to 26, or is that the natural grade?
That's natural grade, yeah.
So is just, I'm being educated here. So if you were to build less than 50 houses, would it make a difference in these figures, these numbers?
Regarding the floodplain?
Yeah. I mean, the floodplain's the floodplain, and when you build on it, no? Okay.
No, we don't have any impact on the floodplain at all. Even the stormwater management ponds, we had to manage the runoff from the ponds to make sure we didn't exceed the pre-runoff. It's actually, the runoff is less than what was going there before, so we'd have a positive impact on the floodplain.
Okay. And then, more or less, just for the record, if this variance happened to be approved, then you have a long way to go and a lot of other authorities that will be checking on, like DNREC and Kent Conservation, all the different, as you go up the line, that will be overseeing and protecting the environment.
Correct.
As expected. Okay.
Yeah, we have to go through DelDOT, Kent Conservation, like you mentioned, Kent Engineering, the Planning Commission. We have to. There's quite a bit of checks and balances along the way.
I kind of just really want record to show that there's a long way to go from this is just the beginning. You have to have the first step, and then, most especially where the environment is concerned. Correct. You have a lot of steps to climb before you get there, and I just really want that to show. And so, essentially, whether you build 30 houses or 50 houses isn't really what creates the impact for what we're talking about for this variance.
Correct. Yeah, it's the location and the elevation more than it is the count.
Okay. Anybody else?
Yes, I have one more. To your knowledge, has either one of the analyses been done previously by anyone else? The hydrologic or hydraulic engineering analysis, has it been done previously and that was expunged, or did I miss something?
No. If the study was done, the floodplain maps would have been updated, and that whether the development's expunged or not, those FEMA maps stay. So I believe, I don't know the dates, but the subdivisions on either side, they were approved before this item was put into the code.
So that would be like Garrison Lake?
Garrison Lake, and then I have the name of the other.
Village of East Ridge.
Yes, correct. Village of East Ridge. Yeah, that subdivision's to the south, of this image here. But those subdivisions were approved a little while back, and they're well under construction. Garrison Lake Green is almost complete, I believe, and the other subdivision is well underway.
Okay, and
the village's subdivision is actually the one I was mentioning earlier. That's set at elevation 17, which is 7 feet lower than what we're proposing.
So this is for the planners. Essentially, our comprehensive plan shows housing there, that in that area. That's
Yes.
residential development.
Yeah,
area.
it's within the growth zone. It has sewer and water, correct? I mean, it has public facilities.
Sewer
all.
and water, everything's code compliant
Yeah.
for the zoning.
I remember that coming up years ago, and that it was ready, and our comprehensive plan, it was in keeping with the comprehensive plan and the developmental intent there. Okay.
Up until last November, I think it was, all the lots were shown on the tax maps too, because it was a recorded subdivision.
Thank you for that. Anybody else?
It's your testimony or your opinion that there won't be any more houses constructed on this site by virtue of this standard being waived, or this requirement to do an H&H study?
No, the plan that's up there now is the one that was approved before, and it's the one we're going through with now. any decisions made tonight won't affect our layout as far as making more lots.
And the results of the H&H study wouldn't be relied upon to deny your subdivision necessarily. They would just be adding information to the floodplain maps that that we rely on for all kinds of reasons.
Correct. I would anticipate that floodplain line moving in either direction, maybe 6 inches. So instead of showing 11, it may show 11 and a half or 10 and a half, either way. I don't anticipate that would change much.
Is there an extensive amount of that land below the red line? Is it considered marsh area and it's very wet as well?
It is, yeah.
If you had to put a percentage on that, what would you say that would be? Like 60% of that land is marshy, or 30%, or?
Yeah, I would probably 60, 70%. It's a big area. I don't know if do we have the aerial? Do we have an aerial for that? Remember if we had a clean aerial up there? Yeah, so if you look down in this area here, you can kind of see the basin itself down here. This basin down here, you can kind of tell just by looking at the vegetation where the marshy area is at. And our site, just for reference, our site is above this tree line here. There's a county sewer line that runs through the back of the project here, and then our site stays up in here outside the woods.
That county sewer line is also a benefit, I'm assuming, correct, for what you're proposing?
We're utilizing it, yes. It was brought in years ago for another subdivision, but there's manholes there that the county engineering has agreed to let us tap into.
Anyone else?
Yeah, I have a question. The 100-year floodplain that you reference, did that take into account the development that occurred in that area, or is it predate the development?
The FEMA maps were just updated recently, and I don't know the date of that map. But what I can tell you is every subdivision has to manage their stormwater runoff, and it cannot increase coming from the site. So even if that site was developed, we're not sending more runoff off the site that would impact those floodplains, myself or the neighboring subdivisions. All of those subdivisions have the same rules and regulations to follow. So I don't anticipate that the floodplain mapping would have changed because of the other subdivisions, because they would have been managed on site.
You're from Newcastle County, correct?
Say that again?
You live in Newcastle County, you work in Newcastle County?
Yeah, all over this. I work all over the state, yes.
You're familiar with Glenville, I assume?
Correct, yes.
But I looked it up while testimony was being given, still listening. There were, 172 houses that had to be bought out by the state of Delaware because they were located within the floodplain. I speculate, although I don't know, that this rule that's new may have something to do with the need to be certain that none of these homes are going to be inundated under any set of circumstances. Now, it's your testimony that the adjacent developments are going to have to manage their own runoff during extreme weather events, but you're asking us for, what did you say, $40,000 to $50,000 and plus time to waive that requirement to get the, what do you refer to it, H&H study, $40,000 to $50,000, and a year, perhaps you said, I think.
2 years.
2 years to go through that process. Glenville exists. Glenville happened. There's a lot of development that's going on in that area. We don't know what's going to happen. I see other farms in the area. Why? I guess I'm asking for for $50,000 in 2 years, why risk millions and millions of dollars of potential expenses if you're wrong? That's my question.
Well, two things. I don't know the specifics. I know about the overall general of that development. I don't know elevation-wise where they were sitting and all that. I can tell you this development, we're 13 feet above that floodplain elevation. And in all the studies I've ever seen and all the studies I've ever done, I've never seen one jump 13 feet when the analysis was done. Never. I mean, if anything, I've seen them actually drop. And the majority of the time, the elevation drops down a little further. To go up 13 feet, that means that entire subdivision next to it would be inundated by 7 feet of water.
Does the H&H study just take into account how floodwaters might encroach on the properties from the adjacent streams? Is that the only thing it looks like, or does it take into account potential runoff from the development that you're proposing, as well as the existing developments and any proposed developments that might occur in the future? Does it take all of that into account?
So we would analyze, we would find out what the drainage basin was draining to that point, and we would look at the land use through there. So we would analyze certain areas as residential and put that in as residential, and roadways are impervious and things. So all that gets put into the system, and then we have to run the calculations to see how much that water backs up at the pipe. So all of that is taken into consideration based on the drainage basin overall. Now it could be, I've never taken it all the way back to see how far it would go. It could be many square miles as far as the area that's studied, but whatever is existing as far as the land use, that is what's input into the system and analyzed.
So it's more than just the elevation of the property above the drainage basin from Garrison Lake. Is that correct? You take into account more than just how a flood event might cause the drainage from Garrison Lake to rise. It's more than just that. It's runoff from the adjacent developments, as
Correct.
well as how rainwater, stormwater might cause that creek to rise.
Correct.
Is the property owned by the developer currently, or is it still for sale? I won't buy. There's a for sale sign there. I think that was discussed earlier, but maybe you can help me understand that better.
So the development is owned by a trust. The original gentleman that owned it passed away a few years ago. There is a builder, he's currently here, who's looking at the site and has it under contract. So he does not own it currently. We're waiting to get some of these approvals in place first.
So the purchase is subject to getting the necessary approvals, not just from the Board of Adjustment, but all the other
everything,
hoops that you
correct.
have to jump through in order to get that approval.
Correct.
But the first step of the first step of the process then to get the waiver, or are we where are we in that?
This waiver is, we're working on getting our letter of objections from all the agencies, because that's construction plan related. But subdivision plan related, we have to get this issue resolved before we can be put on the agenda at the Planning Commission.
There's a lot of development that's going on there. In terms of cost for developing a project of this sort, $50,000 in the overall scheme of things, is that a lot of money?
It doesn't sound like it, but I wouldn't want to write that check. But it is, given the situation, and like I mentioned earlier, a 13-foot jump, the whole bottom part of that map will be flooded out before it even touched our subdivision. It wouldn't even come close. It's a pretty significant drop off out there in the woods.
Yeah, I looked at that property. It looks like, and I drove through the development on the western side so I could access it as far as I could to the back. It appears it slopes off to the back, correct? And then it looks like it kind of slopes inward as well. But I mean, I couldn't access the property obviously, but it looks like it slopes downward. And then you've got all these other homes that abut your property, and the homeowners there, and right now they're looking at trees. Pretty soon they're going to be looking at roads and houses if this goes forward. That's really not, part of what we're discussing this evening, but that's going to change the character of the neighborhood as well. My concern is that this be done properly. $50,000 in the development of this size just seems like a small amount. I mean, you have to have your business reasons for proceeding or not proceeding. I understand that, but I lived in Newcastle County, and I know about the Stanton problem and the 172 houses, and I know that, as you point out, the regulations have changed. There's a reason for that, and you're asking us to set aside those reasons in favor of giving you a variance so that you can proceed without doing the studies. Now, you want me to trust your professional judgment, and I'd like to do that, but I'd like to see it verified.
Well, and the other thing I'll add too, if you look at this map here, this is the FEMA map currently. It's not that far off to what we show on our plan. It's just that this doesn't have an elevation on it. But the line itself that FEMA has established is pretty close to what we show. The only thing that the code's asking for is us to do the study so we can put a number on the plan on the FEMA map. These properties down here, you can tell by just looking at it, these properties down here are going to have a much bigger issue than we would ever have on this property. They're right up against the floodplain, and they don't have the elevation drop off. So this whole process, we're kind of matching the FEMA map as it is. This whole process is to put a number on a FEMA map. That's it.
Thank you.
Thank you. Anybody else? Thank you.
Thank you.
Thank you, Mr. Lobdell. Is there anyone else in the room who would like to speak in favor of this application? In favor? Anyone? Anyone online, Mark?
We have no more participants remaining online at this time.
Thank you. Okay, is there anyone in the room who would like to speak in opposition to this application? In opposition? Anyone? And no one's on the phone line, so hearing no more testimony for or against, the public hearing for A2231 is now officially closed. Okay, the final application for this evening is A2232, Gregory and Jacqueline Barnes. The owner is Pinhook LLC. Is there someone here to represent this application? Great, we'll call you up in a second. Thank you. Again, this is A2232. They're seeking a variance from the requirement that an accessory structure shall not be located in the front yard or front setback of any parcel unless the structure is located at least 100 feet from the front property line, and this is in order to submit a minor subdivision plan. This property is located on the south side of Beechwood Avenue, about 1,220 feet east of Nile Road, south of Dover. It's in the Second Levy Court District, and the zoning is split zoned. It's AC and a little bit of RMH. So a little background on this. So the applicant currently owns a property and they wish to subdivide it. There is a house on there and there is an accessory dwelling unit. Through this subdivision process, they will create two new lots. One will contain a house and the subject accessory structure garage there. And then the other one, kind of shown in the background there, will be its separate parcel too. Currently, they are getting access through another property through a driveway. So they are putting in a subdivision street or a private street called Pinhook Avenue down there at the bottom of the cul-de-sac. Thank you, Jamie. And that will provide frontage to both of those new lots. But the rub is, although this accessory structure is fine where it is now, when they put the road in, the accessory structure will now or then be in front of the house, and not 100 feet from that new road front or front property line, hence the need for the variance. So you can see this is the existing garage. It's currently covered in woods. It's hard to see, and you can see the house there at the bottom. Again, if you can imagine this new private road off to the left there where the blue line is, and you will see then the accessory structure, the garage, will be in front of the house, but not 100 feet in front or from the front property line. This is where they currently get access there off to the left. It's a driveway that snakes around. This just gives you the character of the area on Beechwood there. That's kind of looking around the curve in one direction, and this is the other direction. And this is kind of where you can imagine that private road will go back there, skirting the property line here off to the left. This gives you another idea. The field off to the right looks like it's in soybeans or something, but you can't even see the garage from here, but this is where that private road would extend to provide road frontage and access to each parcel through the private road, and the existing driveway would no longer be required for access. And this is an aerial photograph you can see, and this is further up. You can see there's one lone field left there among a lot of development. Okay, if the applicant could please come up and give your name and address and allow attorney to swear. Oh, Mr. Scott, thank you.
My name is Greg Scott with Scott Engineering, 22 Old Rudnick Lane, Dover, Delaware.
Mr. Scott, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. I provided a little bit of a supplementary write-up in addition to the actual application, which was limited in space, but I'm not going to reiterate that again in the essence of time, but I'd be happy to answer any questions that you might have on that or elaborate on it further. But a couple points I would like to make regarding that is whether the removal of the restriction on the applicant's property would seriously affect the neighboring properties. The answer to that would be no. I mean, the garage has been there for 60 plus years, and by virtue of putting in a right-of-way for that private road, whether it's up against the property where we have it now or we shift it down to be 30 feet plus or minus further away, isn't going to affect the surrounding properties. They're going to see the same thing that they're seeing now. I mean, what happened is that the garage is currently in front of the house as it exists now, but the frontage is off from the road going through the subdivision, and it's much, much further back than 100 feet. But when we put the private road in there, obviously the front of the property now fronted on the Pinhook Avenue, and we came into that restriction. We'd been through the subdivision process. We've had all our approvals. We were down to the point of nearing recordation when it was picked up on a general provision in the code that said it had to be 100 feet back. It wasn't in the setback requirements for the zoning of this property, so it kind of got overlooked. In order to make it come into conformance, we'd have to shift that roadway down. I had provided a sketch, I don't know if you have that or not, to show what that would look like. But it would kind of impede on the subdivision, make the property to the west, make the layout less efficient for him. And although Public Works had indicated we could leave the sewer where it was at, it now pushes that road further to the west, causing the lots on that side to be further away from that sewer line. And it's a relatively flat property, so every inch we have is needed to make that sewer work without having to put in grinder pump stations. So at this point that we're at, without getting the variance on that 100-foot setback, we'd have to go back to the design and change the subdivision layout and as well as the right-of-way layout. You know, it would be a considerable cost to the owner to do that. So we're asking for some latitude there to leave the way the subdivision is designed now with the street at its current location. Be happy to answer any questions you might have.
Go ahead.
Yes, I'm not sure if staff can help me out. Where is that drive or that road going to?
It's in the back of the property.
Do you mean the existing access driveway, Mr. Jenkins? Yeah, gosh, it's hard to see. Up here, yeah, Jamie's got it right. It's under the wood line there.
Right.
If you can see, she's tracing it there.
And that access would be expunged or abandoned, basically, because the lots are going to be subdivided, cutting, through the woods and out towards the branch. So they would now take access off the new Pinhook Avenue.
Anybody else? So I have a question. The reason that they are subdividing this is because to develop 2 lots just for financial reasons to...
Well, the owner's here, so I'd rather let him address that.
Right,
than
well,
me take
we'll
a
ask
look at
him
it.
next.
Yes.
Okay.
Okay.
And then on Exhibit B, you see these things that say foundation, 1 story. Those are that's an existing foundation there?
Yes, those are existing, that's correct.
It's just a foundation, no building?
What's attached to part of the house, and I'd rather let the owners address those. I mean, there's some history behind what's going on the property. But there's an existing house that's there and a foundation that, for whatever reason, hasn't been built on here of late, but...
I'll ask them
Okay.
when they come up. Anybody else? Thank you.
Okay, thank you.
Thank you, Mr. Scott. Anyone else who would like to speak in favor? Yes, please, the owner. If you could state your name and address, please.
My name is Greg Barnes. I live at 290 Beechwood Avenue.
Mr. Barnes, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. As to your question why we wanted to establish Pinhook Avenue, the residence that is roughly the equivalent of the lot, 8.3 acres, was that of my mother and stepfather. During the time that they had that property, which spans about 65 years, if you would, he used the entire area, if you would, for purposes of his garage, his plant sheds. What you're talking about, particularly with that blue building, at the onset was a plant shed for cold storage where he would essentially plant the entire acreage. Over time, it became a garage with 4 doors, and it allowed us to park the equipment that you otherwise need to mow and do various things around the grounds. It's not a business per se, it's just simply for purposes of keeping the area and the upkeep. The reason that we wanted to establish Pinhook, I'm not so sure that it's financial, although if we subdivide and sell the lots, obviously that would be different people that would purchase those lots. For my purposes, if we did do that, I do not want to have 4 different property owners use common access, which is around my house, which is currently there. You asked an earlier question by schematic where the old or current driveway is, and it actually goes to the north side of my house and then runs parallel to the St. Jones River, which is the east side. As you see my house up in the top left, my driveway comes into a garage, but this roadway continues behind my house and runs parallel all the way down the riverbank. So the object in our mind is to provide the access which is available through the field, which we also own, and to make sure that we establish proper right-of-way for Pinhook Avenue and any adjacent lots that would have driveway access. And then they would have an alternate way of connecting to what is essentially 288 Beechwood, the current house that you know in the back. And the other point I would make is that also allows us to establish a sewer line connection that would, to my way of thinking, improve the quality of my mother, stepfather's previous residence, which I've always wanted to do, primarily as opposed to having septic. I hope I've answered your question.
It did, thank you. Does anybody have any questions of the property owner?
Just one quick one based on the last comment. In the center of this schematic, it shows a cesspool. Is that what you're referring to? This would allow for a better septic system, like a standardized central septic versus the cesspool.
This would allow us to connect to the sewer, and I'm not sure I'm answering your question correctly.
One of the schematics that I have, it says approximate location of existing cesspool. So if this was granted, you would be able to connect into the central sewer, correct? And just bypass that.
Yeah, we intend to establish a grinder pump and lift and bring it to the main sewer and eliminate the septics that exist. I'm not sure I'm making the point very clearly. We're very much aware of our property, where it is situated, and we have a great deal of respect and love of the area. It is one of the few remaining areas that I know of in Dover that has old growth forest that still runs the riverbank. And it's our intent with our HOA, which you would see as part of our plan, to be very conscientious and make that impingement on new owners to respect. So the abandonment of the old road, as well as maintaining setback of, I think, 200 feet, I may or may not have that correct, and preserving the trees by approval as to what is cut away for new construction, that all goes hand in part with what we're proposing with our minor subdivision. It's not to change the nature of the area.
So essentially, though, the intent of adding the road is to subdivide to a certain extent and put some houses along in there.
It's to create the addition, 2 lots. I obviously petitioned earlier and created our house, but it's to create structures similar to what we already have, to be part of the common sewer that exists, that was built. In fact, all of Beechwood, as you know, it was built by us 75 years ago and brought forward. So yes, we would have the subdivisions, but it's not my desire initially to try and sell everything. It's to essentially establish it while I own all of the ground and have established right-of-ways that are in place, that if the field, as you see to the west side, were ever to be developed, then the developer would have to be cognizant of our right-of-way in Penhook Avenue and follow that with their subsequent planning if that were the case.
Thank you.
Sure.
Anybody else?
Yeah, and there's a good possibility that this, if you do sell it in the future, that this building is demolished anyway, correct? I mean,
Sorry?
There's a good possibility in the future, as you, excuse me, as you sell these lots, if you do sell the lot, that these buildings get demoed.
Yes, as a matter of fact,
Yeah.
I would anticipate they'll be eliminated along with a new structure being built.
Anybody else? Thank you.
Thank you.
Thank you, Mr. Barnes. Is there anyone else that would like to speak in favor of this application? In the room in favor? Anyone? Mark, anyone online? No, no one online. Is there anyone in the room who would like to speak in opposition to this application? Yes, please come up and state your name.
Good evening, Melissa Harvey, 370 Beechwood Avenue.
Ms. Harvey, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. I just have concerns. Elizabeth Ebert, who actually lives on 332 Beechwood, was supposed to be here tonight. She had a family emergency, so I kind of got notified last minute. I was babysitting my granddaughter. So I guess her biggest concern, and when she spoke with me, is the biggest concern is the access road. Beechwood Avenue is a very quiet, old-school subdivision, and traffic has gotten worse in the last 2 years. I've lived there going on almost 3 years. We've owned our house there almost 2 years. And traffic from the trailer court and all around Beechwood has gotten incredibly worse. There's actually a speed monitor right on 77 Beechwood, towards the end of Beechwood. It's been there for a few months, and our concern is if you put an access road in there and down the road he builds a subdivision, whether it's manufactured home, townhomes, an extension of the trailer park, that is just going to increase the traffic in that small area, in that subdivision, when there's already increased traffic and no respect in regard for the speed limit. I work from home. My husband's retired military, works from home. We see the traffic, and not to mention on 67 Beechwood, my son, daughter-in-law, and 9-month-old granddaughter just bought that house 3 months ago, and the traffic's really bad. So that is our concern with him getting the access, having that private access road, what could be created down the road. 1 or 2, 3 homes, that's different. A big subdivision, extension of the trailer park, that's a huge concern for everybody. In the neighborhood, I know on our end, Elizabeth went ahead and got 19 signatures opposing it for that reason. She never reached even further down, per se, where my son and daughter-in-law live. But I have the signatures here if you need those. But that is our main concern, is the increased traffic if that road is granted and there's a subdivision.
Okay, so based on the testimony this evening, you now understand that there's no intention to subdivide that property and build trailer parks or a lot of housing.
I mean, he had mentioned something, the number 4, possibly, when he had said something. I don't know what that was in relation to. Hard of hearing, so it was hard for me to hear being behind him. I guess I'm ignorant to the laws. I've only been in Delaware going on 3 years. I'm from Erie, Pennsylvania, but you grant him that access for that road, how do we know, is there like stipulations, or that is his road, it's his access, it's his property,
Yeah.
So how can we say?
So here's the thing. So for him to put in a private road, certainly private roads have specification. So what's at hand tonight is the setback for this garage. It's not really, he doesn't need permission to do this subdivision and put the private road in. This variance is just, if he knocked down the garage, we wouldn't even be here tonight.
Gotcha.
If that larger parcel is developed, which I think is your concern, that would be probably subject, I'm pretty sure, to a major subdivision plan that would have to go through Regional Planning Commission and Levy Court for approval, which would be a much more rigorous process than this. Really, what's at hand tonight, again, if he took the garage down, he wouldn't even be here tonight. He can put a private road, he can subdivide administratively as long as they follow the rules for all that. So really what's at hand tonight is simply to legalize the placement of that garage once the road goes in. Okay. So, yeah, I believe me, I understand your concerns, but yeah, I mean, and I see your bigger point, if he wanted to do a manufactured home park, that would be subject to additional public hearings and things such as that. But that's not something that the board really is able to address tonight, from this perspective. It's just a matter of legalizing the placement of the garage when the road goes in there.
No, I appreciate that. Like I said, I'm ignorant. I'm on her behalf.
No, those are good questions.
Like, I see you guys out there mowing your grass. We love our neighborhood. We love all the neighbors. It's just there are young kids, and now that my granddaughter and there's more kids that we're meeting when we walk the dog, that's my only concern. So, and I came here on behalf of her for that issue. But as far as the garage, absolutely. I could care less. I mean, good for him, but I just don't want a big subdivision, or we had enough issues with the trailer park already I'm dealing with, so I don't want an extension of that onto that property.
Certainly, I think you have reasonable issues and complaints, so. I'm just going to check with Mr. Townsend. She did bring with her a lot of signatures, obviously because she felt that the intent was different. So I don't necessarily want to refuse taking them, but I want to know whether I should be taking them or not.
I wouldn't advise you not to receive them into the record. I think we need to pay some attention to what the premise of those signatures is, and it apparently is in opposition to the potential development of that vacant land, which is not what's before us tonight.
So I think probably the best thing for us is to accept your list, just so that it's here and we have an understanding, and the people who may someday read after that they know that that's there. Thank you, Mr. Townsend. So I also just want, well, number one, thank you for supporting someone who stands the watch. It's very important. It's not just them, it's the whole family. Second of all, you're brave to come, and this is a learning curve, and I hope you'll come again. But
I had a heart attack when I walked in here.
Okay. All right, so anybody else? Thank you.
Thank you very much.
Thank you again for your testimony. Is there anyone else here tonight who would like to speak in opposition to this application? Opposition, and no one's online still. Okay, hearing no more testimony for or against the application A22-32, the public hearing is now closed.
Okay. Anybody need a break, or shall we just keep on trucking? Everybody's good? Okay. So we are going to call the business meeting to order. And if you would just call the roll.
Yes, ma'am. Ms. Coleman? Ms. Coleman?
We're taking roll.
I'm here. Thank you. Ms. Hudson?
Here.
Thank you. Mr. Jenkins?
Here.
Thank you. Mr. Nichols?
Here.
Thank you. Mr. Cusick?
Here.
Thank you. And Ms. Denny?
Here.
Thank you.
Okay, first order of business is meetings from last month's meeting, which was September 15th. So I will need a motion.
I'll make a motion to approve the minutes of the Board of Adjustment for the September 15th, 2022 meeting.
Second.
So we have a motion and a second to approve the minutes from September 15th, 2022. All in favor?
Aye.
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 Any nays? Any abstain? Okay. Unanimously, we approve the business meeting minutes from September 15th, 2002. Next item on the agenda is notice of decisions for applications A 2224, 2225, and 2226.
I'll make a motion to approve the notices of decisions for the September 15th, 2022 meeting based upon application A2224, A2225, and A2226.
Second.
Have a motion and a second. All in favor?
Aye.
Aye.
Any nays? Any abstain? Okay, unanimously, the notices of decision from September 15, 22 are hereby approved. On to new business. Let's go with who's here.
Yes, ma'am. So we still have the Fitzwaters. So we will see application A-22-30, the Fitzwaters. They were seeking a variance from the required 30-foot rear elevation setback and 15-foot side setback to legalize the two existing buildings being used for the home-based contractor.
Okay, so do we have any thoughts or discussion?
I have part of a discussion, I guess. When you look at the number of people that came out overwhelmingly in support of, I thought that was to be commended. They took the time and effort to comment on the impact of the business at this point.
I agree that we did have a nice showing, a very good showing of people who are in favor, and I think that speaks for the nature of what's going on there, and some of those neighbors close by, close enough that, especially the catty corner person, enough that if it was a huge nuisance, I would think that there would be some complaint there. So any other comments?
I want to seek clarification, please, if I can, from staff. The owner of the property indicates that the contractor who erected the pole building was aware that it was going to be used for a home-based business. My question is, I want to clarify, there is no permit to operate currently a permit to operate a home-based business at that site. Is that correct?
Correct. So originally, the building was pulled for a residential building. They did not mention anything about the home-based contractor. This was found through the complaint, and they were willing to come in and apply for the home-based contractor, but to even be able to apply for the home-based contractor, they have to go through this process first.
I'm willing to understand that the contractor didn't inform the owner that they needed a variance based upon the building being behind the home. Where it strains credibility that a person who's opening a business didn't know that they needed to get a business permit before they could open a business. Is that common? That happens? That people open businesses and they don't even know they have to get a permit to run a business?
I would say yes.
Yeah, certain businesses, you don't need a license. You can do it as a hobby up to a certain degree, if I'm remembering correctly.
Not necessarily.
For something like this, they would need approval from the county, but unfortunately, I think there is folks out there that don't know that they have to come through our process.
For an auto repair shop?
Sure. And sometimes it's found out through a complaint and they come in and get it situated.
In my years here, I think it happens a lot more than we realize. And then someone makes a complaint, and then you end up here. And I also think it's important that we keep in mind that once the variances if the variance is approved, there's still a ways to go. They go to the next level to seek permission to have a home-based business, and then of course licensing and all the other things. So we're step one, more the baby step, but it has to come first.
Yeah, Mr. Nichols, if it makes you feel better. So if the variance is approved, they have to go, again, apply for home-based contractor. The same, everyone within 200 feet, just like for the variance tonight, will be re-notified of that. If no one objects within 30 days, we can approve it administratively. If someone does, they have to apply for conditional use before Regional Planning Commission and ultimately Levy Court to get that approved, and they still might.
Let me mention this again. I was delayed in looking at this property, and I've discussed this with staff before. I'd like to see the signs on the property when I go to look at them, the public notice signs. There was no public notice sign, and I've heard staff's response to why that's so. But my concern is if this is a major road and there's a home-based business and there's a public notice listed there, people who are driving up and down that road, I don't know when it was removed, but it wasn't there today for whatever reason. That concerns me. It always concerns me when they're not there. The another gentleman who was here this evening brought the sign with him because the sign says return it to Levy Court. Well, this sign wasn't on the site and I don't see it here this evening. It's a detail item. I'd like to talk to staff about that at a later date, but in any event, it wasn't there.
Didn't we cover this a couple of meetings ago where they put it up and then it can come down?
Yeah, we take a photograph for that very reason to show we've legally posted it, but
I know staff put it there. I'm just saying it wasn't there today. for whatever reason.
Okay, so any other discussion or perhaps a motion?
I just to comment on Knott Road, unless I'm confused. I know there's traffic on that road, but I don't know that I would classify it as a major road, only because there's no shoulder on that road, if I recall. Maybe I'm wrong, but I don't recall. I've been down that road extensively doing work in that area, and it's not the best work to be working on the highway with because there is no shoulder.
Do you have an aerial that shows the surrounding area of that property?
Yes, and it is not classified as a major road.
Okay, thank you.
Thank you.
As everybody knows, I don't make motions, but as I look at this and I saw the people who came to speak on their behalf this evening, and the lack thereof of the people who could have come to object or been on the internet, and it appears as though this business has been going on for a while, and everybody has different sensitivities to hearing and to, things like that. But it feels to me as though he's operating a clean and neat business that several, I'm going to say, from what we saw tonight, people, neighbors felt was fine there. So my feeling is that we should allow this man to continue with his livelihood and feed his family. And based on testimony, this is what he does, this is where he does it. And, trying to find or rent or find a place to do it is, I think, is difficult, so.
I'll make a motion for A-22-30. I vote to approve based off the public testimony heard tonight. I believe there's an exceptional practical difficulty on the applicant. We heard his testimony where he was trying to do everything the proper way, just was unaware. And I believe removing the restriction does not seriously negatively affect neighboring properties.
Second.
Okay, so we have a motion and a second, and when you're ready.
Yes, ma'am. Mr. Nichols?
In connection with application A-22-30, applicants are requesting a variance from the provision stating an accessory structure used for home-based contracted establishments to be set back from the public street for right-of-way, minimum distance of 30 feet. I vote to approve the request for variance. Failure to do so would create an exceptional practical difficulty for the owner.
Thank you. Mr. Jenkins?
I vote in support of application A-22-30 based upon the testimony of the applicant and the testimony of his neighbors on the professionalism of the applicant and with the desire to maintain his economic standard of living.
Thank you. Ms. Coleman?
Application A-22-30. I vote to approve the variance based on the unnecessary financial hardship this would cause for the family, and also with the public testimony and the applicant. I vote yes.
Thank you, ma'am. Mr. Cusick?
I vote yes in support of the motion for application A-22-30 to approve. Per the testimony given tonight, I just feel like if he was aware that he would have placed that building in the proper location, and I think the financial impact far outweighs with losing the business, and also the impact the financial cost to relocate that building. I think the minimal impact of neighboring properties, per all the supporters here tonight, also weighed in my decision.
Thank you. Ms. Hudson?
I vote yes per my motion.
Thank you. Ms. Denny?
I'm going to vote yes. Based on the testimony this evening, it somewhat began with the building permit not be, when the permit was filed, there wasn't notification of the nature of the intent of the reason for the pole barn. I feel as though the company who installed the pole barn began this situation, and I have said this often over many years. It feels to me as though if somebody has a license to build, to establish things like that, then what they need to, when they come and apply for these permits for these homeowners or property owners, they need to be upfront and honest. And so based on that testimony alone, I feel that there was an exceptional practical difficulty created when the pole barn installer was less than honest, number one. Number two, again, I feel that he had many neighbors in support of this, and he's supporting his family and with this business. You know, since the beginning of the pandemic, you know, running a business, having a business, and feeding your family can be pretty tough. And so I think it's important that we support his desire to have a home business.
Thank you. That is 6 in favor.
Having received unanimous positive votes, application A2230 is hereby approved.
Thank you. Next, we will see application A-22-31 for Garrison Lake Farms.
To move my papers, otherwise I get very confused. So, Garrison Lake Farms, any discussion, thoughts?
So I don't want to confuse here. It's my question for staff, I guess. It's in my experience that when it comes to the subdivision code, that council is authorized to grant waivers on recommendations from the Board of Adjustment, whereas, from the Planning Commission, recommendations from the Planning Commission, whereas Board of Adjustment grants variances from the zoning code. The Board of Adjustment here is definitely authorized to grant variances from the application of these flood management standards. That is clear. And if you look at the considerations, they seem to go to the question of whether or not structure should be built in a particular place, and whether by granting relief from the standards allows for structures to be located in places they wouldn't otherwise be located, and whether that's potentially harmful to the public. Those standards don't really work very well in considering this application, which is request for relief from the requirement of an H&H study. And the code says that that waivers can be granted. I think it might be, I mean, if their application were to fail tonight, I think there still should be some examination as to whether or not council can grant a waiver from a subdivision code requirement, which is typically the case. You have these subdivision standards that don't come before the Board of Adjustment because they don't involve zoning code requirements. So I'm not saying any of this to influence the outcome of your deliberations with respect to this application, but it does seem to me that maybe a second look at that would might produce a different answer if their application tonight is not.
I looked at this because this is very different for me. And so, you know, sorry, my thumb keeps coming off this button. So I looked at this from the standpoint of, yeah, it is in keeping with a comprehensive plan, and also it got a nod for approval from the planners, which I think is important. And again, I think that the cost for these studies is exorbitant, and it gets worse all the time. But again, this is not something, you know, it's not like our, you know, sliding door to nowhere things that happen and fences that happen all the time. This is a little more unique for me. But and again, this piece of property is, to me, like when I looked at it, and it's the layout of the property is kind of crazy, and the bottom of it you can't even really utilize because of wetlands. And so to me, there's an exceptional practical difficulty that's created by what else can you put there? You know, I mean, they're not looking at like, so, you know, some of these places get so overly crowded, and to me, what they're discussing doesn't seem exorbitant. And I'm just that's not my vote. That's just what I'm saying as I looked at this. But again, this is new to me, and that's such a tiny piece of property. When you see it on the map, the way it's designed, and yet they still are able to preserve areas to give buffers, especially to the development on the left, and then of course it borders a road on the right. So that's again my comment.
I had a question for Mr. Nichols. When you were speaking about the neighborhood that flooded and the state had to buy it, was that around here, or were you just speaking in general?
Sorry, ask me a question again, please.
When you spoke earlier during the testimony that a neighborhood was purchased by the state, was that around here, or was that another?
That was Glenville. That was a buyout. It happened, I don't know when it happened, after 2003. Had multiple floods. They were granted permits to build in the area. I don't know if they were all within the 100-year floodplain, but some were. And in any event, the state, in connection with FEMA, had to buy out 172 property owners. Pardon? Oh, that was in Stanton. I'm sorry. Next to Delaware Park. Again, I have a question of did I answer your question?
I just wanted to know where it was. I didn't know if it was
right
this
next to Delaware Park
neighborhood in the field that we were looking at, or okay.
We're charged with looking at these 11 criteria and determining whether or not to grant this waiver. Is that correct? Question of counsel.
I mean, I think that's what you're doing here tonight. That's what you're going to do tonight. Yes.
I, as a member of this board, can't answer those questions, and we're being asked to rely on the advice of someone who has a financial interest in the matter. I'd rather rely on the advice of somebody who's been engaged to provide a professional opinion, and hopefully is going to act accordingly.
Well, you can put questions to staff.
I have
and staff has made a recommendation on this, but you can ask.
Well, yeah, I understand they have, but they don't have the report either. They're making an assessment based upon their knowledge of the area. Do you have an engineering report, a professional engineer who's looked at this site and would be willing to sign off on giving a waiver for this H&H?
Well, before you answer that, I mean, I think you know that the answer to that question. The provision that I was talking about earlier indicates at B4 that a waiver is authorized. Where is it? I'm sorry.
Mr. Townsend, if I will, in chapter 188, 188-8, it says that these are variances that go through Kent County's Board of Adjustment.
Variances, but this is a waiver. This is, and throughout this chapter, it refers to variances being the authority of the board. But in this case, it's referring to a waiver. And it doesn't say it's referring to a variance. And it says, in subdivisions in which the proposed lots are located outside the floodplain, completion of the study may be waived, provided that the subject area is designated and restricted as open space or conservation area. Well, obviously, the drafters of the ordinance anticipated, and this was drafted. This was not drafted by us. This is adopted by us, but this came from FEMA, I think. I think they had a big hand in this. The adoption of this ordinance had to reflect these FEMA requirements.
Who grants that waiver?
Pardon me?
Who grants the waiver?
No, my point is the drafters are saying that under certain circumstances, you can consider waiving that requirement. So they're anticipating by creating the opportunity for a waiver that there may be appropriate circumstances where the H&H study does not need to be done. And I don't think it's controverted that, I mean, the record is that this is one of those circumstances. Not that you have to grant it, but this is an appropriate application because the area that would be subjected to the H&H study is not being subdivided. Aren't any structures going in it. It's not being subdivided, and it is going to be designated as open space. That's not to say that you have to grant the application in every instance, but the drafters who were imposing the requirement that H&H studies be done anticipated that H&H studies might not be worthwhile or might not benefit the public in certain circumstances like these.
Is a waiver and a variance do they mean the same thing?
Well, I think the county has taken the position that they mean the same thing. I'm not sure that they do. My advice to you is to consider the application in accordance with your with the standards and treat it like it's your responsibility. But I'm not certain that if you were to deny this, that the council would be forbidden from granting the waiver.
Counsel for the board?
No.
Counsel for
the levy court. I'm sorry.
Yeah, you're right, Mr. Townsend. A lot of these waivers, we've had them for sidewalks and numerous other things that go before Regional Planning Commission. As a matter of fact, there's one going before them in December. So for Blue Line Stream and other environmental things. So this one is a little different that it lands before the board.
Well, part of the reason I'm questioning it is because the standards that you're to apply to the application don't seem to help you answer the question. Because there aren't structures being placed in this area where the H&H study is required to be done that could be washed away and cause harm to others. I mean, that's just one example.
It really doesn't fall under like the quick check lines at all. But as you read through the information we were given in our packets, and again, the one thing that struck me initially, when I first looked at it, and then of course as I started to read through, I realized my thoughts were correct, that the comprehensive plan allows for this development And of course, that's written here in the comments from the planners. And again, the bottom of that, you can see where the wetlands are, you know, and they certainly are protective. And then, as it was said this evening, and I said, you know, I'm learning with some of this engineering stuff, but, you know, I've always been happy when we have an engineer on the board because some of this escapes me. But, you know, the water below is not going to get, this isn't going to really affect that. And so to me, and it clearly says in here that, you know, in the information that was given to us under item 8 was that the 218 comprehensive plans allows for this site. So of course that's, you know, they look long and hard at all this stuff. They have their engineers as they're out there. To be developed with low density residential use. And therefore, the proposed use is consistent with the comprehensive plan, which I always think is important. Because bad enough we, you know, the Board of Adjustment has the power to grant variances on different types of land use issues. But then, you know, when you start dealing, you know, like it's like you don't want to start making changes to things in the comprehensive plan. To me, that's a whole different level from what we do. And so I was kind of relieved in seeing that that was part of this. And while I appreciate the reference and understand what my colleague was trying to impart on us, the information about the state having to go back and buy it and all of that, that area, it was not unknown to be a place where there was a lot of water and, you know, people stalling on bridges underneath, you know, and that Christiana was. So this was not like some special secret everybody knew. So that the potential for those things to happen. So anyway, that's my comment.
So, Mr. Townsend, I have a question for you. So this evening, are we grappling with the issue of granting a waiver, giving a variance to allow a waiver for this H&H study?
My recommendation is that you field the application tonight. You hear the application tonight, and you decide it in accordance with the considerations that would apply to a variance from the floodplain management ordinance. That's going to be my recommendation. Although I do question whether the county. I think the county does have. I mean, this is just a very off the cuff, but I think the county does have the authority to grant a waiver of this requirement under certain circumstances. The county's taken the position that only the board can do that, which is a conservative approach. But again, I apologize for distracting us from the issue, but I think I am asking you to apply those considerations that the applicant addressed in its presentation and in its written materials, as well as the considerations that the staff recommendation report made. Hopefully we can get a motion of some sort, and we can get one or more of you to take on those issues, and others can vote their conscience based on accepting the considerations made by others.
So in the staff responses, it's 2, where it says the requirement for a study may be seen as an unnecessary and exceptional hardship for the applicant. Would you want to share your feelings about that. It's a recent aerial photography of the portion of the property that is in and around the map floodplain is predominantly marshy wetlands with overgrown vegetation. Assessing this area to do the field work for a hydraulic study would be difficult. Therefore, the physical characteristics of the site create an exceptional hardship for the owner to comply with this requirement. So that kind of weighed heavy in my feelings.
So, and we did talk about cost, and I'm not unsympathetic to the idea that a cost of a project like this is multiples of $50,000, and $50,000 is not a hugely significant number based on the investment that's involved, but 2 years is.
Yes.
So to me, you've got a property under contract for 2 years. What are the consequences of having a contract that's contingent upon receiving all these approvals for probably would have to be contingent for probably 3 years, because if it takes 2 years to do this study and then you've got to go through the Planning Commission analysis, I mean, that's going to put the parties in a difficult situation. What is the appropriate price? The seller may, if the values are going up, that's what the buyer's betting on. Maybe the seller's going to want to get out of it, and vice versa. I mean, so who knows?
Mr. Townsend, just for clarification, when we make a determination with respect to this variance, it's based on these 11 considerations, and I don't see here how it impacts the proposed buyer of the property. I don't see where that, maybe I'm missing it here, but I don't see where that comes into play with respect to these 11 considerations. Help me with that.
Let's look at the considerations. So the first one you're required is whether there's any danger that materials may be swept onto other lands, injuring others. So as I understand it, the H&H study is required for the area that is part of the parcel, but it's not in the there are no structures that are going in the area where the study would be done. I mean, the elevation, I mean, are they required to map the entire parcel by virtue of doing the H&H study, or is it just this area that's much lower?
I don't know, Mr. Townsend. I mean, the technicalities of the actual study.
Mm-hmm. We do know that the record indicates that the elevation, the record from tonight, the elevation is, was it
11 and a half.
11 and a half feet higher than this area, and that compares favorably to other subdivisions in the area, and there does not seem to be a prevailing issue with floodplain management in those areas. So my experience with applying these standards is when somebody asserts an exceptional practical difficulty because they want to build something in a flood zone, or they want to improve something in a flood zone that's legally non-compliant. And the question is, are you going to allow them to invest money in this existing structure that's legal and non-conforming, if that structure might pose a threat to others as a result of rising floodwaters? Well, there aren't any structures that are going to go in this low area. So I would say the first standard does not cut against granting the waiver.
And a lot of these considerations are close to being the same. I mean, a lot of them have the same response, or that are close to it.
Mm-hmm.
Mr. Townsend.
Yes.
So, I mean, we're focused a lot on that stream from Garrison's Lake and the 100-year floodplain. But what is the definition of flood? Is it just the 100-year floodplain, or does flood encompass runoff from that development, adjacent developments, the fact that so much land is now turned into impermeable structures? I mean, in our normal business affairs, we're always dealing with 25% limitations for impermeable surface. I mean, here you're looking at square miles of it.
So the
So what is the definition of flood?
So I don't have an answer to that question, but the applicant did indicate, and I think this is correct, that in terms of impervious surface, that they're required in the course of constructing this development not to generate more runoff from the property than is currently the case. So they have to get these approvals from DENREC in order to come back. These agency approvals they're referring to, in order to come back through the process and get county approval, they're going to have to meet all the standards that relate to stormwater runoff. I don't know the answer to the definition of flood, but stormwater runoff is, I think, what you're talking about generally when it comes to these developments, and they're not going to be able to develop this without accounting for their stormwater.
And that's, just to add to that, Mr. Townsend, I'm sure that's the reason why retention ponds are dug in subdivisions throughout Kent County. They're extensive. It's a way for stormwater runoff to be managed. You know, retention ponds is just the nature of the beast on any Kent County subdivision in this area.
So that's one of the ways, but there are also underground improvements that are costly and are required to be made in order to deal with your stormwater.
I have, and recently, you know, we've got some things going on in another board I sit on, and it actually pertains to the development of a state property in an area where I sometimes have to leave my office and go all the way back to Wyoming and make the entire square to get back to State Street in Dover because of water issues in certain flood events, which happen. So, you know, and honestly, that, whether I like it or not, really doesn't bear any weight. But, you know, it's like all that you can do is say to the state, okay, you want to do this, then you have to resolve the drainage issues. And I think that they have a plan, and as Mr. Jenkins said, you know, we have DENREC involved and Kent Conservation and those agencies, and that's not like just coming for a board. It's not really even politics. It's just these agencies. And when I managed the town of Camden, believe me, I have dealt with those agencies, and they're not easy. You know, they can bring an engineer right to his knees. Seen it happen. So that's my thoughts.
So, Mr. Townsend, I have a question. If I have three considerations that support my decision for the waiver, am I to incorporate them into a motion to get this moving?
Yeah, but I think we need to run down each consideration, or at least have one or two people run down through the considerations and mark them all, and just, there's like 20, 11 plus 7, so 18 of them.
Yeah, any grant of a variance from the floodplain management requirements requires you to make an affirmative on those 7 items, and then I think you can move pretty quickly through the others, as they don't relate very well to the application. But you've got to make an affirmative finding on the items that are listed in the county's report at 3.1, right? That's on page 4. Paragraph Roman numeral 3.
Yeah, the showing of good and sufficient cause. I'm going to make a motion to approve application A22-31 per staff recommendation, and also I feel like this applicant checks the 11 responses to considerations and the 7 limitations for variance. We'll run down these the danger that materials may be swept onto other lands to the injury of others. I just feel like per the testimony, the applicant stated that the FEMA map clearly states the study is pretty close to where our property land just stops at 11.3, I think it says, and then his elevation, which is 65 feet off of this flood map, is at 13 feet above that, which is at elevation 24. So I think it has no impact for any danger of materials being swept into that land. The danger to life and property due to flooding or erosion damage, same thing. I believe we are 13 feet above the elevation that the FEMA map states. 3, the accessibility of the proposed development and its contents to flood damage and the effect of such damage on the individual owner. Same response. We're 13 feet above, and we're also building outside of the floodplain. The importance of the service provided by the proposed development to the community. The residential development will provide housing to the community, and that's in compliance with the county's comprehensive plan. The availability of alternative locations for the proposed use, which are not subject to flooding or erosion damage. Same response to item 1. We're above the stated 11 floodplain flood elevation, and we're at 24. The necessity of facility of a waterfront location. There's no waterfront lots being proposed on this site. The compatibility of the proposed use with existing anticipated development. Again, it's primary residential in nature in this area, and yeah, it's in the Kent County Grosso with sewer and public water available. The relationship of the proposed use of the comprehensive plan, as stated, it's within the county's 2018 comprehensive plan. The safety of access to the property in times of flood for ordinary and emergency vehicles. Again, we have no concerns with flooding on this lot, with the flood elevation 13 above what the FEMA map says, and then also our structures are not within the floodplain. The expected heights, velocity, duration, really not applicable to this site. Wave action. The cost of providing government service during and after flood conditions, including maintenance and repair of public utilities. Again, I feel like this site will not flood. We're 13 feet above the FEMA flood elevation. The response to limitations, shown of good and sufficient cause. A good and sufficient cause is one that deals solely with the physical characters of the property and cannot be based on the character of the planned construction or substantial improvement. The personal characteristics of the owner or inhabitants or local provisions that regulate standards other than health and public safety standards. As stated earlier, we're 13 feet above the flood elevation at 24, and also our structures are outside this flood zone per the map.
And these areas are not being subdivided either, as
correct. So the areas will not be subdivided. It will be developed as one area as a residential community. A determination that failure to grant the variance would result in exceptional practical hardship due to physical characters of the property. The H&H study will cost, and then the cost factor to do the study, as well as the time that is anticipated, 2 to 3 years per testimony that takes to do that study, and also the field work that's required to do this study in this overgrown area is a practical difficult. The increased costs or inconvenience of meeting the requirements of these regulations does not constitute an exceptional hardship to the applicant. Same thing, the monetary cost and the time lost to perform the study. A determination that the granting of a variance for development within a designated floodway or special flood hazard area with base flood elevations, but not floodway, will not result in increased flood heights beyond that which is allowed in these regulations. We're not building any structures, no proposed development within that floodway per the map. A determination that granting of a variance will not result in additional threats to public safety, extraordinary public expense, nuisance, fraud on or victimization of the public, or conflict with existing laws. Again, I feel like no threat to the flood and threat to this site based on the flood elevation stated per the testimony. A determination that the structure or other development is protected by methods to minimize flood damages. Same thing. We're building outside the flood zone and also the flood and also the elevation per the testimony. A determination that the variance is the minimum necessary, considering the flood hazard, to afford relief. The same thing. He's not building within the flood zone and the elevation stated.
I'll second.
So we have a motion, a second.
Yes, ma'am. Mr. Jenkins?
I vote in support of application A22-31 based upon the testimony of the engineer this evening, and the project is consistent with the character of the area, and the evidence that's been presented to us about the plane level is consistent throughout.
Thank you. Ms. Coleman?
For A2231, I vote to approve the variance because the physical characteristics of the site create an exceptional hardship for the owner to comply with the requirement.
Thank you. Mr. Nichols?
In connection with A22-31, I vote to deny the request for a variance. FEMA guidelines specify that the H&H study needs to be done. Increased costs or inconvenience in meeting the requirements of the regulations does not constitute an exceptional hardship to the applicant. So I vote to deny.
Thank you. Sorry. Ms. Hudson?
For A-22-31, I vote to approve the variance from not doing the H&H study based off the staff recommendation, the public testimony that we heard from the engineer tonight, and I believe that the study would be an exceptional practical difficulty on the applicant with the time needed to do the study, and I'd like to agree with what Brian said.
Thank you. Mr. Cusick?
I vote yes per my motion.
Thank you. Ms. Denny?
I vote yes. As I really considered this, even just from my home, and of course we really did, the testimony this evening was based really mostly from the applicant, with no one really having any objections. And as you go over the response by the planners to the consideration, it appears to me as though there are many more positive comments as they make the recommendation to approve this. And so, I think granting the waiver is, in this particular instance, should be done. And this especially, because of course we don't do these, and this is very kind of new even to me, but I want to be very specific about not setting precedents in this particular, this does not make a precedence for me. This is unique, so much that is unique about this particular property. The lay of the land, the comprehensive plan, so many other things, so yes.
Thank you, ma'am. That's 5 in favor of the motion and 1 in opposition of the motion.
Having received the majority positive votes, application A 2231 is hereby approved.
Thank you. Next, we will hear application A-22-27. I'm sorry, we had a applicant in the back I didn't know about. This is for Mountain Consulting, seeking a variance from the front setback of 75, and they are proposing a 50-foot front setback.
Well, this is the unique property that has the stream in the back and the shape.
May I express a concern? While the applicant indicated this is to be used as a single-family home, it's owned by an LLC, an insurance entity, I believe. I visited that site, and this Halltown Road, that is located right on a bend. It's hard to see down that road. I don't know if 50 feet or 75 feet, if it matters, but it's right on the curve. Can we look at that aerial again of that site? There you go. Can you go out further, or is that all you have? There you go. You can't see down that road. Now, the adjacent property owner was concerned about the ability for her tenants in the rear to see I guess either way, well, probably to the right. My concern is people being able to see to the left. It's quite a sharp turn. Now, I guess if it's a residential structure and it's used for solely that purpose, I guess you're not going to have as much traffic. But if that turned into a commercial entity, and again, it's owned by a commercial enterprise, I guess that's a whole set of
You can put a residential house in an LLC. You do it for legal protection. And if he wanted to go commercial, he'd have to have a change in the zoning.
My concern, correct, I understand. My concern is that if ever did change, there was a zoning change and we allowed that to happen and it was subsequently approved.
But there was also a property on that lot. He had the mobile home was on that property.
It was a camper, apparently, but I don't know. There's nothing there now. It's vacant. It's just a bunch of trees and, well, it's not even trees.
And the property to the left is actually closer to the road than the projected house.
Pardon me, repeat that.
The house that you're talking about is actually closer to the property than the projected house that they want to build.
Staff indicates that's the case, but we're talking about today and the standards that are applicable today. And my question is, do we want to maintain those standards, or are we just going to
But also we're looking to stay in the characteristic of the surrounding area. And if you look to the left, all those houses are in front of where they want to be built. So it would stay within the characteristic of the surrounding area.
The proposed use,
Pardon?
the proposed use according to the application is residential.
Residential, I understand.
And they would have, in order to change this to business, I think there'd be a lot of hoops and meetings to attend. And when you consider the size of the property, I would wonder.
And if he did commercial, if I'm not mistaken, I think he'd have to come back for another variance to have 150 or 200 feet road frontage. Isn't it more than residential?
I think another factor to consider is how many car lengths is it down that lane. If you're approaching Halltown Road, if that's the concern about line of sight and traffic, if that's our concern about the residents in the back, that lane, if you're exiting that lane to get on Halltown Road, 50 feet is, I don't know how many car lengths, but there should be more than enough clearance to get out onto the highway from that lane. If you look at the line of sight of the houses to the west of Halltown Road, south and west, that house, the new house, should be right in that line of sight from the highway.
Could I ask staff, what's the approximate square footage or acreage of that lot?
0.54 of an acre, and that's by the deed.
You couldn't put commercial there anyway.
I mean, they could rezone it to BG technically, as long as they could fit a commercial space in there. But again, I don't think we should take that into consideration.
No, I don't think so either.
I don't think we need to, right, but that's a half-acre lot, which is undevelopable without a variance.
The 100 foot from the top of bank of the Blue Line stream would just about cross over, or I'm sorry, actually it would cross over the 75-foot front setback.
So without a variance, that property cannot be developed.
Yes, because if you see here, the 75 is in red. This blue line demonstrates 66 feet from the top of bank. So if you imagine that even farther, if it was the required 100 feet, if they weren't granted a waiver, that would cross over the 75.
And it's the general application of those requirements, 75 feet from, in this case, Halltown Road, 100 feet from the Blue Line stream?
Yes,
from the Blue Line stream, that for certain properties creates an exceptional practical difficulty in an effort to develop them. And what apparently is the case here is that we've got one of those properties. We have the presence of a stream, and we have an oddly shaped property, which is legal. It's a legally sized lot. It's a half-acre lot. It's bigger than the lots to the left of it, I believe, which have homes on them. And without a variance, you couldn't develop it.
Yeah, when you look at the shape of the property, most especially the Blue Line stream, I mean, when you just look at the angles and, you know, the required setbacks without the variance, I wholeheartedly agree. This is very much like we're prohibiting the, you know, use of this property, and they're not asking to build a mansion either. They're asking, you know, for a manufactured housing, you know, so to me, it's not only along with the recommendation, it's a logical thing to do.
I would like to make a motion to grant a variance for application A22-27 from the 75-foot front setback, based on the fact that the irregularity of the lot, the configuration, and the Blue Line stream makes it an exceptional practical difficulty.
Second.
Motion a second, whenever you're ready.
Thank you, ma'am. Mr. Cuse? Just the one.
Yeah, we don't have to do the blue stream line.
Mr. Cusick?
I vote yes to approve the motion to application A22-27. I think it fits within the character of the community, minimum impact to the neighboring properties, and then the hardship is the uniqueness of the lot, to be able to develop a standard residential dwelling here.
Thank you. Ms. Coleman?
I vote to approve the applicant's request A2227 to allow for a 50-foot front setback because there was an exceptional practical difficulty demonstrated.
Thank you. Mr. Nichols?
In connection with application A-22-27, I vote to deny the request for waiver. My concern has to do with the nature of the property and the fact that it resides in a corner. I'm concerned about egress and ingress to the property.
Thank you. Ms. Hudson?
For A-22-27, I vote to approve the motion. I believe that, excuse me, I vote to approve based off staff recommendation, public testimony that we heard tonight. I believe this is exceptional practical difficulty on the home property owner with the blue line stream being the way it is, and the angle of this property makes it truly unique.
Thank you. Mr. Jenkins?
Yes, I support A-22-27 per my motion.
Thank you. Ms. Denny?
I'm going to vote yes to approve. I see lots of exceptional practical difficulties just created by the shape and configuration of this, the configuration of the property, and, you know, again, most especially the blue line stream issue. And frankly, I think if we did not approve this, then, as was mentioned by the staff, we're creating an exceptional practical difficulty for this property owner. So I think they're brave to buy it, and I hope they do something nice with it.
Thank you, ma'am. That's 5 in favor of the motion, 1 in opposition.
Having received appropriate amount of positive votes, application A-22-27 is hereby approved.
Next, we have application A-22-29 for the state of Delaware. They were seeking a variance from the requirement that all entrances and exits from the site be set back at least 10 feet from the adjoining property lines to allow the submission of a site plan.
Okay. Discussion, thoughts, or motion?
In connection with A-22-29, I'd like to make a motion to remove the restriction of a 10-foot setback from an entrance and exit way to site to allow for a cross-access agreement between the subject parcel and the parcel to the west, as it would not seriously affect the neighboring properties. I recommend that we, my motion is to approve the request for variance.
Second.
Thank you.
Motion is second when you're ready.
Thank you. Mr. Cusick?
I vote yes to approve the motion to application A-22-29. Doesn't have any effect to the immediate vicinity. No effect to the neighboring properties, as the cross access is owned by the same property. With very unlikely the state of Delaware will sell the property, and also the hardship of the financial cost to relocate the existing driveway.
Thank you. Ms. Coleman?
For A-22-29, I vote to approve the variance because there was an exceptional practical difficulty demonstrated, and removal of the restriction would bring the existing entrance into compliance.
Thank you. Mr. Jenkins?
I vote in support of application A-22-29 based upon the testimony of the applicant and the minimal impact from the restrictions that are being made.
Thank you. Ms. Hudson?
For A-22-29, I vote yes per the motion. I vote based off staff recommendation, public testimony heard tonight, and I believe that removing the restriction does not negatively change the property.
Thank you.
Stays within the characteristics, sorry.
Sorry. Mr. Nichols?
In connection with A-22-29, I vote to approve the variance per my motion.
Thank you. Ms. Denny?
On application A2229, I vote to approve. I definitely think that in order to provide a more reasonable office space there, we need to do this. Otherwise, I think we will create an exceptional practical difficulty for the state.
Thank you, ma'am. That's 5 in favor of the of the motion, I'm sorry.
Having received unanimous positive votes, application A2229 is hereby approved.
Next, we have application A-22-32 for Gregory and Jacqueline Barnes. They were seeking a variance to approve an accessory structure in the front setback.
Discussion, comments?
So this is just for the shed. This is not for anything else.
Exactly. Like there was a lot of discussion about the road, but it's not, we're not talking about the road.
I'll make a motion to approve A-22-32. Yeah, oh, sorry. Okay. I would like to make a motion based off the staff recommendation that we heard tonight, the public testimony, and I believe removing this restriction would not seriously affect neighboring property and stays within the characteristic of the surrounding property. Okay, and for the variance from the garage would be 63.5 feet from the new property line.
Second.
We have a motion, a second when you're ready.
Thank you, ma'am. Ms. Coleman?
For A22-32, I vote to approve the variance because there was an exceptional practical difficulty demonstrated.
Thank you. Mr. Jenkins?
I vote in support of application A22-32 for two reasons. First, the impact should be minimal since this building was there since 1959, and also the applicant is making a sincere effort to grant some type of secondary access to these parcels.
Thank you. Mr. Nichols?
In connection with A22-32, I vote to approve the variance because the only reason the garage is now in front is because of the new road, to require that the owner change the road would represent an exceptional practical difficulty.
Thank you. Mr. Cusick?
I vote yes to the motion to approve application A22-32. Minimum impact on neighboring properties. This garage has been there since 1960 and sits back from the neighboring properties. It's a hardship to the applicant for them to be able to develop a private lane.
Thank you. Ms. Hudson?
I vote yes per my motion.
Thank you. Ms. Denny?
I'm going to vote yes. I think that we definitely, and this is like the key word, the phrase of the night, but not doing this would certainly create an exceptional practical difficulty for this applicant. The current ingress egress to that property, the distance of it, the fact that it passes past his private home, all of the above, I think it's the right thing to do here.
Thank you, ma'am. That's 6 in favor of the motion.
Having received unanimous positive votes, application A 2232 is hereby approved. Looking for a motion to adjourn.
I'll make a motion to adjourn.
Second.
All in favor?
Aye.
Aye. Have a good night.